Can a pro se defendant do better than his court-appointed counsel at a double attempted murder trial? You know the saying, right? Here, I'll let Ariana Grande say it.
Mr. Brown, I've seen a lot of cases, and I tend to agree with the prosecution. You've chosen to represent yourself, which, as the saying goes, implies that you have a fool for a client.
Now, let me present to you our main character, Justin. On an early morning somewhere in Florida, two brothers were going about their day as normal until an unusual gray SUV pulled into their driveway. The driver of this SUV was none other than Justin, the man who eventually would be charged with attempted murder against each of the two brothers, Jonas and Andre. According to the state, Justin arrived at the brothers' residence and after a dispute attacked one of the brothers, Jonas. This attack led the other brother, Andre, to get involved and try to fight off Justin away from his brother. Before Andre was able to do this, Justin fired off a shot, but luckily he missed. Justin ended up fleeing the scene shortly thereafter. Today on Deep Dive True Crime, we get to watch Justin representing himself at his trial. He has a long criminal history but no training as a lawyer. Let's see how he does.
Very serious. CF 3436, State of Florida versus Justin Hinson. Mr. Hinson is here, seated at the counsel table. He is pro se. Ms. Jankowski is here. Mr. Hinson, are you handcuffed, shackled, or restrained in any way?
No, sir, Your Honor.
All right, very well. You wish me to read the instruction on the defendant's right to remain silent in the opening instructions? Mr. Hinson, you wish me to read the instruction on the defendant's right to remain silent in the opening instructions?
Yes,
I can hear you.
Yes, sir, Your Honor.
Okay. Either side aware of any special jury instructions that will be requested?
No, Your Honor.
Mr. Hinson?
No, sir.
Have all the exhibits been marked?
Yes, sir.
Been shared with Mr. Hinson?
Not yet, Judge.
We expect any recordings or projectors to be used?
Yes, sir.
Have you checked on those to make sure they're working properly and that you know how to work them?
I need to do that. I'm not as familiar with this courtroom.
Are there any witnesses here?
Yes, sir.
Is the rule to be invoked?
Yes, sir.
All right, let's go ahead and bring them in.
I have a question, Your Honor.
We're not dealing with questions right now, Mr. Hinson.
I'm smart about the recording that she's talking about.
We're not dealing with questions right now.
I think it's on his control panel. It's facing this way. Right up here. Here.
Oh.
I'm pretty sure it's open.
All right, folks, you all have been identified as witnesses in this case. A rule of procedure has been invoked which requires that all the witnesses remain outside of the courtroom except when you are actually on the witness stand testifying. While you are outside of the courtroom, you are instructed not to discuss your testimony amongst yourselves or in the presence of any other witness. You are, however, at liberty to discuss your testimony with either of the parties in the case, Mr. Henson or the state attorney, provided you do so outside the presence of any other witness. This rule applies until the trial is over or until I specifically inform you otherwise. If you violate this rule, you may be disqualified as a witness, and you also may be punished by contempt, which can mean jail, fines, or both. No one wants to see that happen to any of you, so please judiciously respect the rule. I'll ask Ms. Jankowski and Mr. Henson to notify all the witnesses who are not currently present for this instruction that the rule has been invoked. So would all of you please step outside. Please don't go too far, because when we need to call you as a witness, we don't want to have to hunt the whole courthouse for you. Thank you. Yes. All right, folks, you're reminded of the trial management order. Your opening statements are limited to 45 minutes. If you need more time, please notify me of that prior to the expiration of the trial. I will consider a request for more time. I have an exhibit list from the state. I don't have a witness list.
Yes, sir. I have one, Mayor Coach.
Yes. All right, thank you. Mr. Henson, any witnesses you plan on calling? Mr. Henson?
Yes, sir. Miss Crystal Monestein.
Okay, hear you, sir. Kristen what?
Crystal Monestein.
Spell the last name.
Monestine.
Monestine?
Yes, sir.
All right, ma'am, you've been identified as a witness. Please step outside.
And Judge, if I may,
Yes.
she was not listed on any defense witness list, so before she's called, I would just ask the court to allow me to have access to her.
All right, Mr. Henson, why was she not listed on your discovery?
I didn't think I would need her to testify on it, but I mean, she don't have to, but I didn't think I was gonna need her to testify. It's just like I didn't know she was supposed to be using the recording, and she said she wasn't gonna use it.
We're not talking about the recording. I'm talking about your witness is not on the
I
witness
didn't think
list.
I was gonna need her to testify.
When did you decide that you needed her?
Just here recently, probably.
That's not very specific, Mr. Henson. What do you mean by just here recently?
Recently, probably a couple days ago, when I was looking over everything, and
Why didn't you notify the state attorney?
it was short notice, it was a couple days ago, it was just like Thursday or Friday, so it's kind of hard to notify her. I'm in jail, so it's kind of hard to notify her. Like,
We've talked about that several times, the fact that you're representing yourself and you're in jail. What do you expect Ms. Monestine to testify to?
The things that were spoken to her after this incident occurred.
What specifically?
About the she was told by actually the ex-girlfriend of this guy that it was all in their cahoots to set me up on everything that's going on, because like I've been telling Ms. Jankowski, I ain't doing nothing wrong, man. I was attacked. I didn't have anything. I only had on my jury when I was attacked. That's it. And the ex-girlfriend of this guy, Ms. Oliver, she went to my wife, telling her that she was sorry that they were trying to do this to me, and
Who's your wife?
Ms. Monstein.
Okay. All right, well, we'll give the state attorney an opportunity to talk to your witness prior to her being called. I'll reserve on any motions until that time. Do you have an exhibit list, sir? Any exhibits you plan on entering?
No, sir. The only thing I have is just pictures of the ring that I had on upon the altercation. That's it. I don't have any physical exhibits to.
Are you planning on admitting those pictures in evidence?
Yes, sir.
Give them to the bailiff so I can take a look at them.
And Judge, I have not seen these yet either.
Okay.
I just received them. Thank you.
All right, would you mind handing those to the state attorney? Let her take a look. Thank you. Yes. Okay. All right, so let's move on to Mr. Hinson's question. You had a question, sir?
Yes, sir. I was wondering what recording that Ms. Jankowski was speaking on, because I know in the earlier court date, the prior court date, she said that she wasn't using any of that because I wasn't able to see it. So we came to a conclusion that she wasn't using any of that. You asked her, how much was it? She said 25 hours worth. And you say, well, how much of that are you using in trial? Do you plan on using 25 hours of it in trial? And she responded, no. You asked her how much? She said none of it. So I'm trying to see what recording is she, insisting using. If she responded, none of it.
All right, Ms. Jankowski, I don't specifically recall that conversation, but maybe I'm just misremembering it.
Mr. Hinson is referring to the body camera footage and the cell bright and the recorded interviews. I do not plan on introducing any of that. Instead, this is the 911 call.
All right. All right, so she's just going to use the 911 call, Mr. Hinson. You have any other questions?
No, sir, Young.
All right, anything from the state at this point?
I do have an order tennis motion, Judge.
Okay.
Frankly, I'm only doing this motion because Mr. Hinson is pro se, so I wanted to have a discussion on the record about it. I expect the defendant is likely going to be attempting to elicit prior acts of domestic violence between Ms. Savannah Osborne and Jonas Allen. Jonas Allen is one of the victims in this case. I would ask that all references, questions, or evidence otherwise pertaining to domestic violence allegations be not allowed pursuant to character evidence relevance 403, 401.
So acts of domestic violence between Jonas Allen and Savannah Osborne?
Yes, sir.
All right, Mr. Hinson, you planning on eliciting any testimony in that?
No, sir, not at all, Your Honor. That's coming from one of her witnesses, not me.
I'm sorry, unless what?
I said, no, sir, not at all, Your Honor. I said, that's coming from one of her witnesses, not me, so I don't have any plans on using
All right, very well. So I will grant that motion. You're instructed not to go into that area. If you think that somehow the door has been opened to that testimony, you are to alert me to that. We'll have a discussion about it outside the presence of the jury. Understood?
Yes, sir.
All right. We had one juror contact my office last week, Miss Kimlin Tran, told us that she had a doctor's appointment today and was wishing to be excused. We inquired further as to what the schedule was to see if we could accommodate her doctor's appointment. The word we got back was that the appointment was at 11 and that it took several hours. Obviously, because of the subject matter, we didn't inquire further into the nature of the appointment. So she was instructed to be here at 8:30. I'm told by the bailiff that as of about 5 minutes ago, she had not reported. So I don't know whether she's just running late or whether she's just decided to excuse herself. In any event, we're going to have to decide what to do with Miss Tran. If she appears, then we need to know whether you all want to excuse her. If she fails to appear, then obviously we need to replace her with the alternate. So, any update on Miss Tran? Clerk here? Yeah, as she's in there, let's find out that.
Want to have a request to the court, please?
All right, stand by just a second. Not there.
You prefer to have them all in the first row?
Put them all in the first row.
Yes.
Yeah. All right, Mr. Henson, you had another issue?
Yes, sir. I just asked the court to inquire into the alleged juror misconduct or alleged exposure to jurors to improper influences or information. I'm asking that each juror is questioned under oath or in the alternative altogether in order to reveal if anyone went on any site, engine, i.e. Google, internet, etc., and discovered information on defendant background or present housing location or address. Please, if you don't mind.
All right, that request will be denied as to individual inquiry. I ask all of them prior to swearing them in whether they have heard or learned anything about the case since we were all together last Monday. That should be sufficient.
You asked them, did they go on in the search engine or i.e. Google or anything like that on the internet?
No.
That would be appropriate, I feel so.
That request is denied. Anything else from either side?
That's it.
All right, let's take about a 10-minute recess. By that clock back there, it's a little after 10 minutes till the hour. Let's be back in here and ready to go at 9 o'clock. Mr. Jankowski, in that time, I hope you will take the opportunity to figure out how that machine works.
Yes, sir.
All right, see you in all about 10 minutes. Thank you. right, let's have a discussion about Kimlin Tran. This is the juror I spoke about earlier. According to the clerk, she is not here. They have tried to call her, and they are getting nothing but a voicemail. That would appear to bring up our first alternate, which is Cortez Randall. Anyone want to be heard on that?
No, sir.
No, sir. I thought he was already on the jury, Your Honor.
That was incorrect. All right. Well, the clerk will, and the record will reflect that we're going. I will excuse Miss Kimlin Tran from service on this jury. However, I will issue an order to show cause to Miss Tran to explain why she did not appear. It may be that there was a legitimate medical incident. She did say she had an appointment, but the latest information we had was that the appointment was not till 11 o'clock, and that's why I asked her to be here this morning. All right. Anything from either side before we bring the jury panel in?
No, Your Honor.
Your Honor, I would like to challenge the jurisdiction of the court, Your Honor.
On what grounds?
To see if the state even has or have had jurisdiction to proceed with this case under Basso versus Utah Power and Light Company. Jurisdiction can be challenged at any time and has to be proven, Your Honor.
All right, very well. I'll deny that. Let's go ahead and bring in the jury.
All right, the jury.
All right, everyone, please be seated. Good morning, ladies and gentlemen. Welcome back to Circuit Court in Leon County. Once again, I am Circuit Judge Frank Allman. Is the state ready to proceed?
Yes, Your Honor.
Defense ready?
Yes, Your Honor.
All right, very well. We are here in case number 21 CF 3436. Table, state attorney is also present. I hope you all had a restful evening and a good week. Please raise your hand if you have learned or heard anything about this case since you were selected to serve a week ago Monday. All right, very well. No hands. Madam Clerk, would you please administer the oath to the panel?
Please raise your right hand. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and evidence? If so, say I will.
All right. Thank you very much. Ladies and gentlemen, you have been selected and now sworn as the jury to try the case of the state of Florida versus Justin Hinson. This is a criminal case. Mr. Hinson is charged with 2 counts of attempted first-degree murder with a firearm and 2 counts of aggravated battery with a firearm. The definition of these offenses will be explained to you later. Before we go any further, let me just tell you, whenever you enter or leave the room, you're going to see everybody out there stands up. That's as a show of respect to you and what you're being asked to do in this trial. When you get to your chairs, just go ahead and sit down. You don't need to stand up. So the state's charging document, which is called an information, was read to you last Monday. The information is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against Mr. Hinson in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the parties will have an opportunity, if they wish, to make an opening statement. The opening statement gives the parties an opportunity to tell you what evidence they believe will be presented during the trial. However, what the parties say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After all of the evidence has been presented, I will give you both oral and written instructions on the law. The parties will then have an opportunity to make their closing arguments. Following the closing arguments by the parties, I will conclude with your final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any fixed or definite opinion on the merits of the case until you have heard all of the evidence, the argument from the parties, and your instructions on the law from me. Until that time, you must not discuss this case amongst yourselves. Your verdict must be based solely on the evidence or the lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case, and you cannot look up any information about the case. If you become aware of any violation of any of these rules, please notify court personnel so they can advise me. During the course of the trial, we will take recesses, during which time you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss this case with anyone, nor permit anyone to discuss the case with you or say anything to you or in your presence about the case. If anyone does attempt to say anything to you or in your presence about the case, please tell him or her to stop because you are serving on the jury. If he or she persists, please leave that person at once and immediately report the matter to the bailiff, who will advise me. All of your cell phones, computers, laptops, or any other type of electronic device must be turned off or in silent mode while you are here in the courtroom. You may use these devices during any of the recesses I discussed, but even then you must not use any of these devices to try to find out any information about the case or to communicate with anyone about the case or the people and the places involved in it. Do not take photographs, video recordings, or audio recordings of the proceedings in court or of your fellow jurors at any time. After each recess, please double-check to make sure that your cell phone or other device is turned off or in silent mode. At the end of the case, while you are deliberating, you cannot have these devices in the jury room because you cannot communicate with anyone outside of the jury room. The bailiff will collect them for you and guard them, keep them safe. If someone does need to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided to you if it's not already on that whiteboard in there. This case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the state attorney, and me. Jurors must not conduct any type of investigation on their own. This includes reading newspapers, watching television, using a computer, cell phone, the internet, any electronic device, or any means whatsoever to get information related to the case or the people and the places involved in it. This rule applies whether you are in the courthouse, at home, or anywhere else. You must not visit any of the places mentioned in the trial, or you use the internet to look up maps or pictures to see any of the places discussed during the trial. Jurors must not have any discussions of any sort with friends or family members about the case or the people and the places involved in it. So please do not let even your closest family members make comments to you or ask you questions about the trial. In this age of electronic communication, I want to stress that you must not use devices to talk about the case. You must not talk to anyone face to face. You must not use cell phones, computers, or any other electronic device to communicate about the case. So do not send or accept any messages related to this case or to your jury service. Do not discuss this case or ask for advice from anyone by any means at all, including posting information on an internet website, chat room, or blog. These rules are imposed because jurors must decide the case without distraction and only on the evidence presented here in the courtroom. If you investigate, research, or make any inquiries on your own, I, as the judge, have no way to make sure the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or to challenge the accuracy of what you might find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of the proceedings, and a mistrial could result, which would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you could subject yourself to contempt proceedings, and again, no one wants to see that happen to any of you. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The parties are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer the question. During the trial, it may be necessary for me to confer with the parties outside of your hearing in order to discuss matters that require consideration by me alone. It is impossible to predict when these conferences may be required or how long they will last. When they occur, rest assured they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If it's something that I think can be handled in a matter of a moment or two, we'll step over here to the side and have a sidebar conversation. If it's something that's going to take any longer than that, we'll send you back to the jury room so you'll be more comfortable rather than sitting there watching us whispering in the corner. If you would like to take notes during the trial, you may do so. Do you all have notepads? You do. You are, on the other hand, you are not required to take notes if you don't want to. Taking notes is left up to each one of you individually. You have been provided with a notepad and a pen to use if you wish to take notes. Any notes that you take will be for your personal use. However, do not take them with you from the courtroom. During recesses, please leave your notepads face down on your chairs. You will be able to have your notes in the jury room during your deliberations. After you have completed your deliberations, the bailiff will collect your notes. They will be destroyed. No one, including me, will ever read your notes. If you do take notes, please do not get so involved in note-taking that you become distracted from the proceedings. How witnesses act during their testimony can be just as important as what they say. Your notes should only be used as aids to your memory. You will notice that during the trial, I will be taking notes. Please understand that because our roles as judge and jury are different, I will be taking notes for different reasons than you as jurors. I tell you that so just if you see me writing something down, it doesn't mean that's something that you should be writing down as well. And just because I'm not writing something down doesn't mean that you can't take notes if you want to. Again, whether or not to take notes is left up to each one of you individually. And whether or not you do take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater than each juror's memory of the evidence. During the trial, if you have a question, during the trial, you may have a question you think should be asked of a witness. If so, there is a procedure by which you can request that I ask the witness your question. After the parties have completed their questioning of the witness, raise your hand if you have a question. I will give you sufficient time to write the question on a piece of your notepad paper, fold it, and give it to the bailiff, who will pass it along to me. I do ask that even if your question is a short one, tear out an entire page from your notepad. The clerk has to keep track of all the questions, and if you tear out just a little scrap of paper with your question on it, it makes it very difficult for them to keep track of those. You must not show your question to anyone, and you must not discuss it with anyone. I will review the question with the parties. Under our law, only certain evidence may be considered by a jury in determining their verdict. Your questions are bound by the same rules of evidence that control the questions of the parties. If I decide that your question may not be asked under our rules of evidence, I will tell you that. Otherwise, I will direct the question to the witness. The parties can then ask follow-up questions if they wish. If there are additional questions from members of the jury, we will follow the same procedure again. Now, folks, by providing for this procedure, I do not mean to suggest that you must or even should submit written questions for the witnesses. In most cases, you will see that the parties have asked all of the necessary questions. But don't be shy. I'll look over there. If you have a question, make sure you raise your hand. Once the witness steps off the witness stand, your opportunity to ask that witness a question is over. The parties will now have an opportunity to present their opening statements. Remember, what they say is not evidence, and you must not consider it as such. However, I do encourage you to give the opening statements careful attention. They are intended to give you an understanding of the evidence that the parties expect you to hear and to highlight any issues in the case. After any opening statements have been given, you will then begin hearing evidence. Ms. Jankowski, does the state care to give an opening?
Yes, Your Honor.
Whenever you're ready.
Thank you, Judge. All right, good morning, everybody. So like Judge Allman said, opening statements are just my opportunity and Mr. Hinson's opportunity to tell you what we expect that you'll hear throughout this trial. But I ask you to remember before we get started what we talked about in jury selection of this being real life. I can tell you what I expect to hear. I can tell you what I expect you'll see. But you'll be meeting some people, namely Jonas Allen, Andre Rollison, their neighbors, and the detectives and officers involved in this case, and they're going to tell you what happened that day. So what I expect you'll hear is that on December 22nd, 2021, Andre was at his house. Jonas was at his house. So Jonas Allen lives at 1344 Roomba Lane. He doesn't have a car, but his brother Andre Rollison picks him up to take him to work. You'll hear that around 7:30 a.m., Jonas hears a knock on the door. More like a bang. He figures it's his brother there to pick him up to take him to work. You'll hear that he opens the door, and he's expecting it to be his brother, so he's not paying much attention. He's still on his phone, and all of a sudden, he gets whipped with a pistol in the face. And he will tell you it was by him, the defendant. He'll tell you that he gets pistol whipped, and you'll see the photos of his injuries and the black eye and the scar he still has to this day. And he'll tell you that within seconds, the defendant is making his way into Jonas's apartment, and Jonas is backing up and backing up and backing up. And as he's backing up, it's a small place, the defendant takes that same pistol, points it at his head, and fires. And you'll hear, thank God for Mr. Jonas. He missed. And we talked in jury selection about how do you know something happened when you weren't there? And we talked about circumstantial evidence. You obviously weren't there when Mr. Hinson tried to kill Jonas Allen, but you'll see projectiles. You'll see the bullet mark that the bullet went into on the stairs. You'll hear Jonas Allen describe where he was in the apartment when Mr. Hinson tried to kill him. And you'll be able to see that that shot was at head level. And you'll hear that Jonas Allen, when he describes the gunshot, and it goes like this. And I ask that when Mr. Allen is testifying, that you pay attention to his body language, his eyes, how he's moving, because when he will be telling you what happened, you can see him relive it. So Mr. Hinson tries to shoot Mr. Allen, but remember, his brother, Andre Rollinson, was coming to pick Jonas Allen up from work. And thank goodness he does. And he rolls up to the house in his own car and sees the front door open with this man on top of his brother, sees a gun in his hand, his brother bleeding, and he runs into the house. And you'll hear when he runs into the house, Mr. Hinson turns his attention on him. He too gets whipped with that pistol right in the eye. You'll hear they're fighting at one point. Andre will tell you that Mr. Hinson got on the ground. He was pushed on the ground when they were tussling, and Andre's on top of him like this, just swinging. What's interesting is Andre will tell you that Mr. Hinson, when he was getting those punches, saying, "Oh, I like that. Oh, I like that." You may not think that's much, but we'll talk about later in closing argument why little things like that you hear are going to be so important when rendering your verdict. You'll hear that Mr. Rollinson and Mr. Allen noticed that the defendant's eyes were red. He was talking crazy. You'll hear that after Mr. Rollinson, Andre comes in and the brother tries to intervene and get Mr. Hinson off of him, and he's pistol whipped. He gets Mr. Hinson on the ground. At one point, they're back up. And the way it's described, these are their words, is there's a Mexican standoff, right? If anyone's ever seen that Spider-Man meme where everyone's like this? They say that you'll hear that Mr. Allen is kind of by the stairs. Mr. Rollinson, his brother, is right here. And Mr. Hinson is in front of them, kind of like a triangle. And that's when Mr. Hinson tries to shoot Andre. And you'll see that shot because you'll see the sliding glass door completely shattered. When this is happening, Mr. Allen, realizing his brother is now almost getting killed, he runs upstairs to grab his own firearm. He'll tell you that he bought one about a year prior during the COVID stimulus checks. He's a young man. He finally had the money to buy the protection that every person should have in this town. And you'll see that he legally owned that firearm. So he ran up to get his firearm to come back down because he had no idea if Mr. Hinson was going to take more shots at them. And as he's running down, you'll see, or you'll hear Mr. Rollinson describe that the defendant then takes off. He runs out the door, jumps down the steps that you have to get down to get into the driveway, and takes off in his car. You'll even hear that Mr. Allen, obviously, he's pumped up, adrenaline rushing through him. He has to be calmed down by his brother. He says, "Don't shoot at him. Don't run after him. It's not worth it. Let him go." And so he lets him go. So Mr. Hinson takes off, and the brothers take off in their own car. Obviously, they know that he knows where they live. And they want to get out of there. So they call 911, tell them what just happened, that this guy just came to my house and tried to kill us. And they say, "We actually got a phone call. Law enforcement's already on their way." And you'll hear later that a neighbor heard the gunshot and called 911. So the brothers turn around, get back to the house, meet with law enforcement, photos are taken, a protective sweep of the house is done, and obviously detectives then do their thing. And that's when we kind of learn this story. Because obviously, no one should just do this randomly, right? Even Mr. Henson said in his voir dire with all of y'all, why would someone go around attacking someone randomly? Here's the story. Jonas Allen used to date someone named Savannah Osborne. You might hear her sometimes called Rose. That's her middle name, and that's what she goes by. Jonas and Rose were dating for, I think, like 4 years. He'll obviously know better. But they had broken up. But they were living together at the time, and financially, they couldn't afford to get out of the lease. So they're in that super awkward situation where they're no longer a romantic couple, but they've got 3-4 months left in their lease to just brave it out, hang tight, because they have nowhere else to go, and then they can go their separate ways. And obviously, when you're hearing about the situation, you can imagine how difficult that might be. So you'll hear that Savannah Rose Osborne starts dating the defendant in that time. And I would imagine that once you hear that, you will know the rest. Jealousy, anger, frustration, tempers that are unmatched, except when you're talking about relationships. So you'll hear that the night before Mr. Henson tried to kill the brothers, Savannah Osborne and Mr. Allen got into a fight. They were arguing about custody of her younger brother. She wanted Jonas to help take care of him. And to Mr. Allen's defense, no, we're broken up. I'm not going to take care of your brother. I wish him the best, but we're not together anymore. And this starts an argument. And you'll hear from Mr. Allen just what all that was about. I don't really know, and I don't want to put words in his mouth. But Mr. Henson hears about this argument. He's already jealous about Jonas. He's already mad his girlfriend's living with his ex. But what does he do? He gets high, comes over at 7:30 in the morning, immediately pistol whips the man who opens the door, tries to kill him, and tries to kill the guy who tries to save him. And you'll hear that he takes off, never says a word to law enforcement until he's arrested. So there's 3 people we're talking about. Jonas, Andre, the brothers, and the defendant. You'll see that 2 of those 3 had injuries, the brothers. You'll see that 2 of those 3 stayed at the house and talked to law enforcement, the brothers. Mr. Henson doesn't say a peep. But I expect that today you'll be hearing that, oh, this was self-defense. That's why Mr. Henson's here today. But the guilty man flees when no one pursues. And I'm going to ask at the end of this trial that you find the defendant guilty.
All right, very well. Mr. Jensen, you care to make an opening?
Yes, sir.
Whenever you're ready.
Good morning, everyone. How you guys doing? My name is Justin Henson. I'm representing myself this morning. Ladies and gentlemen of the jury, I stand here wrongly accused of the crimes of attempted murder ×2 with a premeditated design and aggravated battery with the use of a firearm ×2. Very serious offenses. Today we share light on everything that happened prior to that morning. You shall see otherwise, and what I may have defended myself. At the end of this trial, we are going to ask, we want a verdict of not guilty. The only appropriate verdict in the case. December 22nd, 2021, I would like to title this Opening Multiple Shots, One Shell. The prosecution will have you to believe that I, Justin Henson, perpetrated the heinous act of premeditated attempted murder, using a firearm, which I never possessed. It was just me, myself, and I, that crazy morning, just as I am standing presenting in front of you today. Ladies and gentlemen of the courts, you will hear testimony from the alleged victims that play out like scenes from movies we all have seen before, like Friday, Bad Boys, etc. We had multiple statements from officers of the Tallahassee Police Department, many of those alleged victims, as well as the witnesses, which include close friends. They have been subpoenaed to be here today. Today, this has become a big game, too far to quit and come back from. This is not a game or movie for me, this is my life. During this trial, we will see that this was a fight between three people, in which two of those were attacking me. The state will present their evidence and try to convince you that I, Justin Henson, went to someone's residence, committed a crime as heinous as these charges. I did not have a motive to do anything like what I'm being charged with to them or anyone in my life, not even grasp the thought. I received a call from my friend Savannah Osborne asking me for a ride home from work, so I picked her up. Upon arriving at her home, which she shared, she stated she was unable to find her keys. So I got out of my vehicle and lightly knocked on the door so someone could let her in if anyone was home. I turned and made my way back down, headed back to my car. The front door swings open aggressively, almost startling me. At that moment, I turned to see a man which I now know to be Mr. Allen shouting, "Then you say you was going to kick my ass." Excuse my language. Allen began striking me with a closed fist multiple times. I pushed Mr. Allen just enough to use my arms as a guard from his punches. I was able to throw a few punches of my own while trying to avoid stumbling down the steps. We continued to exchange punches as we stumbled towards the entrance of his home. But we was pushed from behind by the alleged victim's brother, Mr. Rollison. Immediately after falling, Mr. Rollison began punching me in the back of my head as Mr. Allen and I were entangled on the floor. As I tried to get myself up off the floor, I bit Mr. Allen in an attempt to free myself. Mr. Allen was holding my arm while Mr. Rollison continued beating me. For a brief moment, Mr. Rollison stopped attacking me, but soon after I heard the first gunshot, I bit Mr. Allen again and yelled at him, "Let me go," fearing for my life. Then I heard a second gunshot followed by glass shattering. Mr. Allen then released me from his grip and I immediately got up off the ground just a few steps from the door entrance and ran for my life. I tripped over the parking block, stumbling to my vehicle where the door had remained open and the car was still running. From there I drove off as fast as I could, driving home to my family shaken up by the events that just took place. I'm just happy to be alive. When I was unnamed detained January 6, 2022 of these offenses, I presented what happened on the day of December 22nd, 2021. The arresting officer informed them the arresting officers informed them that I was the one who was attacked by two women. I did not know and was defending myself. I met with a response from the police that he didn't believe me simply because I didn't contact police. Willfully guilty of these false allegations set before me. The only thing I had on my hand was a ring, which I have pictures to present from evidence today. Though my vehicle was searched and no weapon was found, I was thrown in jail after being informed that this was my punishment for not calling the police after the altercation. I did not call the police following the aftermath, some might ask. My godbrother, whom my mother raised alongside me,
was gunned down by officers in 2019 following a dispute at his residence in front of his children for unknown reasons. As for myself, I was just glad to have laid it out of this situation with my wife. It was not hit by a stray bullet. Never in my wildest dream did I imagine that I would go to jail or even have to stand here before you in this courtroom fighting for my life for defending myself after giving a friend a ride home. I wasn't the only one who left the scene. Everyone left the scene. At that moment, what was I supposed to do? I'm pretty sure any one of you guys in the jury today, if you heard gunshots, we're not trying to see where they came from. We're not trying to see who's shooting. We're just trying to get away from what's going on. The lack of evidence and the inconsistency in all of the statements given from the alleged victims as well as witnesses will prove that this is a matter of self-defense and not premeditated attempt to murder or aggravated battery with a firearm. At the conclusion of this trial, I ask that you find that I am not guilty. The prosecution will not meet their burden of proof. A verdict guilty would be a travesty. Thank you, ladies and gentlemen.
All right, very well. Thank you very much. State ready to call their first witness?
Yes, Your Honor. State called Shelby Mosley.
All right. Ms. Mosley. All right, ma'am, come on up here, please. Maybe come right over here and sit right here.
Yes, ma'am. Thank
Before
you.
you sit down, if you'd raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
All right, have a seat, please. And speak loudly enough that we can all hear you. Go ahead, Ms. Jankowski.
Good morning.
Hi.
Hi. You're going to have to speak up a little bit, okay? And lean into that microphone if you could. Can you please introduce yourself to our jury?
Hi, I'm Shelby Mosley.
And where do you live, Shelby?
1342 Rumba Lane,
Rumba?
Mm-hmm.
Okay.
Ocala.
And what do you do? Are you in school?
No, I'm a stay-at-home mom.
Okay. I want to direct your attention to December 22nd, 2021. Was there a reason you had to call 911 that day?
I'm not really sure of the dates anymore. It's been a long time, but if it's the day that I called the cops, yes, I was just laying in bed and there was a gunshot twice.
All right. Tell me what you remember hearing.
I was awake, laying in bed. I heard one gunshot, but I didn't think anything of it because it's Tallahassee. And then I heard another one along with fighting, just voices yelling back and forth, which I've heard many times before because it wasn't uncommon for the arguing from them.
Sure.
So upon the second gunshot, I was like, nope, this is right outside my window. I'm calling the cops because I got nervous and I was home alone with my toddler.
Okay. So you said you heard 2 gunshots, right? All right. May I approach, Judge?
Yes.
And do you recognize that disc I just handed you? How do you recognize it?
You need to answer out
Oh,
loud.
yes, you brought it to me outside to sign.
Okay. Is that your signature, your initials on the bottom?
Yes,
Is that the 911 call you made that day?
I believe so.
All right, Judge, I move into evidence states 1.
Any objection?
No, sir.
All right, be admitted without objection.
Permission to publish?
Yes.
All right, we're gonna try something else. Just state will publish dates when later, and I have no further questions.
All right, very well. Any cross-examination?
How you doing, Miss Mosley?
I'm fine. How are you?
How I'm making it. You remember writing a written sworn statement, right?
Yes.
You said you was on the phone with police.
Yes.
I remember you saying in deposition that
Objection.
Sustained.
you said that you saw
Objection.
Mr. Hinson,
yes, sir.
if you're going to impeach the witness, you need to do it properly.
I'm just going over deposition, Johnny. I apologize.
Are you asking permission to approach the witness? You need to do that before you do it.
Yes, that is my handwriting.
You need to get near a microphone.
Yes, that's my handwriting.
Did you say you remember that written sworn statement?
Yes.
You just agreed? Yes, ma'am. Could you elaborate on what happened on that call?
I was just on the phone with the officer the entire time. She was a woman. She was asking me questions. She asked me to look out the window. I was uncomfortable doing so, as it was right outside my window that it was happening. I think I looked once, but it was to just confirm that everything was still happening outside. Just explained to her as what was happening after the two gunshots. There were no more, just arguing, yelling, woman kind of like crying.
Right. So you actually didn't see anything, or?
I saw two people, but not enough to get a good look because I was not going to look out my window continuously.
No further question, Your Honor.
All right, any redirect?
No more.
All right, may this witness be excused to go about her business?
Yes, sir.
All right, thank you very much, ma'am. You are
Thank you, Ms. Mosley, for your cooperation.
Any other witnesses or any other evidence from the state?
Yes, sir. The state called Officer Michael Terranova.
Officer Terranova. All right, sir, come right up here, please. Before you sit down, if you'd raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do. All right, have a seat, please, sir. And speak loudly enough that we can all hear you.
Okay.
Go ahead, Ms. Jankowski.
Thank you. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Officer Michael Terranova with the Tallahassee Police Department.
And how long have you been with TPD?
Approximately 16 years.
And what's currently your role at TPD?
I'm currently assigned to the Northwest Uniformed Patrol Division.
What does that mean?
I answer calls for service on the northwest side of the city of Tallahassee.
Okay. I want to direct your attention to December 22nd, 2021. Were you on duty that day?
Yes, I was.
Tell me about how you first got involved with an incident at 1344 Rumba Lane.
So on that date at that time, I was assigned to the Uniformed Patrol Division, northwest side of the city of Tallahassee, and I was dispatched to a disturbance at that location.
And what happened when you arrived?
I arrived at the location. There was no one at the target location, which was 1344 Rumba Lane. We made contact with the complainant, who was next door at 1342 Rumba Lane, to confirm that 1344 was actually the location and that we were at the right location. We attempted to contact at the door of the target location, 1344 Rumba, got no answer. Due to the circumstances of the call that we were dispatched to, with possible gunshots fired, and two males that were involved in a physical confrontation and a female who was screaming, we decided at that point to conduct a protective sweep of the target location, 1344 Rumba, to ensure that there were no injured subjects inside the apartment that may have needed to be rendered aid or in need of help. So,
Let me stop you right there. When you did a protective sweep of the apartment, was anyone inside?
no.
Your Honor, may I approach?
Yes.
Showing the witness what's been marked as 6A through 6J.
Okay.
And if you could, officer, take a moment and look through those photos, and when you're done, look up at me. All right, do you recognize those?
I do.
And what do you recognize those as?
I recognize this to be the location of 1344 Rumba Lane, the location that I responded to.
Your Honor, at this time, I'd move into evidence 6A through 6J.
Any objection?
No, sir.
All right, be admitted without objection.
So after you swept the apartment, what did you do next?
After the apartment was cleared, we exited, and at that point, two individuals showed up in a black Lexus, passenger car.
Okay. Was that Jonas Allen and Andre Rollison?
That's correct.
All right. Did they have injuries on them?
Yes, both of those individuals had injuries.
Your Honor, may I approach?
Yes.
I'm showing you what's been marked as 2A through 2K and 3A through 3C. And again, with those officers, officer, if you could just look through those and let me know when you're done. All right. Do you recognize those photos?
I do.
And without telling us what's in there, what do they represent?
So these photos are of two individuals, the ones I made contact with that arrived on scene in the black Lexus. Once they exited the vehicle, I checked on injuries. I made contact with Jonas Allen and then Andre Rollison, which is both of these individuals in these photos. Each one of those individuals sustained injury. They had, each one of them had
Well, let me stop you right there. At this time, state moves 2A through K into evidence.
Any objection?
No, sir, Your Honor, not at the moment.
All right, be admitted without objection.
And Your Honor, state moves into evidence 3A through 3C.
I'm sorry?
3A through 3C.
Have we seen those?
Yes, sir.
All right. Any objection 3A through 3C?
3A through 3C, I would need to see which ones are they.
All right. Yes.
No, sir, Your Honor.
All right, be admitted without objection.
Officer, when you arrived on scene, was Mr. Hinson there?
no, he was not, that I'm aware of.
Are you aware if he ever returned to the location?
I'm not aware.
I have nothing further.
Any cross-examination?
Good morning, Chair Lowe.
Good.
That's good. You say you've been working for South Police Department for 16 years,
Yes, sir.
and you're aware of the incident that happened on December 22nd, 2021.
I am.
It says here that you had contact with Andre Rollison,
Yes, that's correct.
and you're aware of what he told you in the report.
Yes.
You mind, you want to take a look at it?
I've got my report right
Got
here.
your report?
Yes, sir.
Was he on the oath when he gave you that report, sir?
I'm not sure if I read him a perjury warning or not when I spoke with him.
But this is what he said, and that he said he responded that it was true and correct when he gave it to you.
Yes, that's correct.
Okay. So there shouldn't be no discrepancies in this report that he has given.
That's correct.
All right, thank you. No further questions, Your Honor.
Any redirect?
No, Your Honor.
All right, may this witness be excused to go about his business?
Yes, sir.
All right, thank you, officer.
Thank you, Mr. Chair Lowe.
Any other witnesses or other evidence?
Yes, they called Officer Christopher Woods.
What was the last name?
Woods?
Thank you.
Woods? All right, sir, come right up here, please.
Yes, sir.
Before you sit down, if you would raise your right hand.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, have a seat, please, and speak loudly enough that we can all hear you.
Yes, ma'am.
Go ahead, Ms. Jankowski.
Thank you, Judge. Good morning.
Good morning.
Can you please introduce yourself to our jury?
My name is Officer Christopher Woods of the Tallahassee Police Department.
What do you do for a living?
I'm a police officer with the City of Tallahassee. I'm
How long
currently
you-
assigned to patrol and in a patrol status.
And how long have you been with TPD?
I've been with TPD for 12 and a half years.
Okay. Do you remember responding to 1344 Roomba Lane on December 22nd, 2021?
Yes, ma'am, I do.
What was your duties on scene?
Multiple officers responded fairly simultaneously because of the nature of the call. And as we got on scene, we began initially looking for the location, looking for the address, and trying to locate a victim.
Okay. Did you eventually search the house?
I did not search the house, but I was outside of the house while it was being searched.
Well, let me ask you this. Did you eventually recover a casing?
I did locate a firearm casing, yes, ma'am.
Okay. Your Honor, may I approach?
Yes.
I'm showing you what's been already entered into evidence as States 6C and 6D.
Objection, Your Honor.
Let's have a sidebar, please.
It's grounds for the objection.
In Mr. Hall's report, they did find the casing, but it was in the neighbor's home. It says right here in the report.
All right, very well. The objection is overruled. You can ask him a question about that. Thank you.
The objection is overruled. Go ahead, Ms. Jankowski.
Thank you, Judge. I handed you, I believe it's 6C and 6D. Did you have a moment to look at that?
Yes, ma'am.
Is that the casing you found inside 1344 Roomba?
It appears to be.
Judge, may I approach?
Yes.
I'm showing you what's State's Exhibit 9. Do you recognize that?
Independently, I do not, but it's marked as if one of our evidence technicians.
Is that the case number for TPD on the front?
Yes, ma'am, it is.
And is that the casing that you found that day?
It's in the package, but it feels like it is a casing. Yes, ma'am.
Your Honor, at this time I move into evidence States 9.
Any objection?
Not at the moment, Your Honor.
All right. Can we open it up so we can take a look at it?
Sure. Deputy, do you have scissors and gloves? May I approach that?
Yes.
If you could, Officer Woods, just go ahead and open up the evidence package. If you could put gloves on before you do, please.
Is there a particular way you want me to open this as far as the evidence tape is concerned?
You could just cut it open. We'll clean it over and see if there's more evidence here. For the record, Mr. Officer Woods opened up the package and found inside
It
another
is
package.
contained in another envelope. That appears to be the same casing that I located. It's in the photographs here.
You hold it up for the jury?
It is a 9mm brass round casing.
Thank you.
So Exhibit 9 admitted without objection.
And Officer Woods, do you remember going out onto the back porch?
I remember making a cursory check of the residence after we determined there was no victims inside for other evidence.
Do you remember the back porch being covered in dog feces?
I do not, no ma'am.
That's all right. No further questions.
Any cross-examination?
Good morning, Mr. Woods.
Good morning.
My name is Justin Henson. I'm a defendant of the case. You say you was there the morning of the incident.
Yes, sir.
How did you get involved in the incident, sir?
I was dispatched to it by my consolidated dispatch agency.
Yes, sir. Who did you have contact with when you arrived at the incident?
I had contact with a female. I don't recall independently her name.
You say you just stated that you found that casing. Where was it found?
It was located at the address of residence in the foyer just inside the doorway, the front door.
Okay. I have a deposition here that says that you initially found it in
Objection.
Mrs. Hildebrand home.
Mr. Hinson, there's an objection. When there's an objection, you need to stop and let me hear it. What's the grounds for the objection?
Improper impeachment charge.
All right, sustained. You can show him the item you want him to review and then ask him a question about it.
Can I approach you on?
Yes. Step back to the podium, please.
Can I approach?
Yes.
Thank you.
What is it that you're showing him, Mr. Hinson?
I'm actually showing him where he actually made contact with
Hinson, what is the nature of the document?
the casing that he found.
What sort of papers are you showing?
It's the depositions, Your Honor.
All right, fair enough. So you're showing him his deposition?
Yes, sir.
All right, very well. Go ahead.
It shows that he made contact with Ms. Hildebrand twice. As he said,
Go ahead and ask him a question.
He said officers was already had made contact with her several times. Right?
I'm not sure that I understand the question, sir.
You say the second time that you went to Mrs. Hildebrand home, officers was already there, and you collected that. Well, you didn't collect it. You say you found that casing and you marked it for forensic.
I did not mark it. I located it.
You located
after
it.
the initial victim described the area that the incident occurred.
And that was,
as he described the area, I searched the area that he described.
And that was
the
Miss
casing on the floor.
That was Miss Hildebrand home?
It was 1344 Rumba. If that's where she lives, and that's correct.
I'm not sure. I think Miss Hildebrand was 46. I'm not sure. 44 is where officers were called to, but it shows that this was located in 46.
Is there a question there, Mr. Henson?
Yes, sir. I want to ask you, what did Ms. Hildebrand state at that moment?
I don't.
I stand by. What's the grounds for the objection?
Hearsay, Judge.
Sustained.
Can I approach you?
Yes.
Thank you.
What is it that you're showing him?
Deposition, Your Honor. Another part of the deposition.
Oh, very well. Go ahead.
Did it look like this altercation occurred the way that they say it occurred to you, sir?
I did not witness the altercation. I simply went by what I was being told by the identified victim and potential witness at the time.
All right. You said that they arrived together. You said they
I
arrived.
never said anyone arrived together.
You didn't state
Not that I
that.
can
I
recall.
thought you
When
stated
did
that
I
earlier.
say that?
All right. Well, hang on. Both of you cannot talk at the same time. So if he's answering a question, you need to stop talking. And if he's asking a question, the witness needs to stop talking. Go ahead, Mr. Henson.
Yeah, I thought you stated that earlier when you first came in. I apologize. So the scene didn't look as in if all of this occurred the way they saying it occurred. You say you didn't witness it. I know you didn't witness it. And other than that, it would be hearsay. But I'm just trying to figure out. We're all trying to figure out. That's what the state and the attorney said in the end of your deposition, said they was confused. You were aware of that? Can I approach you on?
No, we can have a sidebar.
All right, Mr. Henson, I'm trying to give you a lot of latitude, but you can't just get up there and talk. You're up there to ask him a question, and then when you're done asking him a question, you need to give him the time to answer it. You don't just get up there and make a rambling speech. So go ahead with your next question. All right, I don't want to talk you down in front of the jury, but if you give me no choice, I will have to. Do you understand?
Yes, sir.
Yeah.
Go to your next question, Mr. Henson.
So on that day, did you search Miss Hildebrand's home?
I entered Miss Hildebrand's home.
You didn't search
If that
her
is
home?
the address that we're speaking to in question, to look for evidence of the incident that was alleged.
Did you search Jonas Allen's home at any point?
I don't know who Jonas Allen is, or
He
He's the victim?
one of the supposed alleged victims, yes,
okay.
sir.
If he lives at the same address as she, then yes.
Mm-hmm. You say you only located one casing,
I located one handgun casing, yes.
multiple shots. What?
The
What?
victim advised there were 2 shots
One casing.
and 1 casing, yes, sir.
Yes, sir. No further questions. Can I approach you on?
Yes.
Mm-hmm.
Any redirect?
Yes, sir.
Whenever you're ready.
Just to be clear, you searched 1344 Roomba Lane?
At this point, ma'am, it was 1344, 1346, wherever the actual call was directed to.
Judge, may I approach with Officer Wood's report?
Yes.
If you could take a look at that, let me know if that refreshes your memory as to the address.
According to the supplement I wrote that day, it was 1344 Rumble Lane.
Thank you, Judge. I have nothing further.
Any of the jurors have a question? All right, ma'am, would you go ahead and write it down, please? All right, just hand them to the bailiff. Let me see the parties at sidebar.
Question is, who is Miss Hildebrand?
They'll find out later. He probably doesn't know.
There you are. Thank you.
I'm told that question will be answered by a future witness. All right, anything else from this witness?
No, Your Honor.
Maybe he excused to go about his business?
Yes, sir.
All right, sir, thank you. You are excused.
Oh,
Just leave those right there. Thank you. Any other witnesses or other evidence from the state?
Let me go sidebar.
Yes.
Sorry, I should have said this before we sat down. My next two are the victims. That'll be lengthy. I don't know if this is a good time for a bathroom break.
All right. We'll take about 15 minutes. Thanks.
All right, folks, I'm told the next series of witnesses may take some time, so we've been at it for roughly an hour, so we're going to go ahead and take about a 15-minute recess. Just leave your notepads face down, retire to the jury room. We'll call you in as soon as we're ready for you. Thank you. All right, everyone can be seated. Anything we need to discuss before we take a recess of our own?
No, Your Honor.
All right. Anything from you, Mr. Henson?
No, Your Honor, not at the moment.
All right, we'll see you in 15 minutes.
Yes, sir.